Ae o ka poe o Hawai, Olu ana kiki o Hawai. Ae o ka poe o Hawai, O mau ka olelo o Hawai. Hawai poe
Just grab that one right there. Yeah. Okay. Good afternoon, everyone, and aloha. Thank you for being patient as we begin our Legislative Hawaiian Caucus. Today we have some exciting information that we're hopeful that we can receive from our speakers. But what we'd like to do is first explain to all of you what the Legislative Hawaiian Caucus does as part of our process to ensure that we can be better informed, to have a conversation with community, with agencies, with individuals on important issues that are before us. Today in our Kuka session, as you all know, the ceded lands issue is one of the issues that many of us have been talking about, hearing, and we'd really like to have this forum as an informational forum for us, but as well as for you folks in the discussion that we're going to take place today. So there will be no testimony, and I just wanted to make that clear. It's really for the legislators to talk directly to the people involved on the issue.
Thank you very much for inviting me to talk to the caucus. I'm very happy to be here. I think it's important, especially for people who may not be familiar with the entirety of the ceded land lawsuit issue, to provide some background. And I know that there are many people in the audience and many people, if not everyone here, who are legislators who are familiar with most, if not all of this, that in 1959, when Hawaii became a state, there was a fairly lengthy law called the Hawaii Admission Act, which set the terms under which Hawaii became a state. And in one of the sections of that act, Section 5F, the United States discussed the terms under which what are now the public lands of Hawaii, sometimes referred to as the ceded lands or the Ceded Land Trust or the Public Land Trust, would come to the state. And they came to the state in fee simple, which means that ownership was transferred from the United States to the state. These are a portion of the lands that were the former crown and government lands of the Kingdom of Hawaii. The total amount of the lands that were the former crown and government lands was about 1.8 million acres. What came to the state was about 1.2 million acres in Section 5F, another 200,000 or so acres that went to the Department of Hawaiian Homelands, and the United States kept about 350,000 acres for its own usage. And what part of Section 5F provides is that these lands, the 1.2 million acres, not the 200,000 Hawaiian home acres, but the 1.2 million acres, the lands together with the proceeds from the sale or other disposition of these lands and their income, shall be held by the state as a public trust. And then there were 5 purposes that the lands, the proceeds from sale, and the revenues were to be held for. 1, for the support of the public schools and other public educational institutions. 2, for the betterment of the conditions of Native Hawaiians, as defined in the Hawaiian Homes Commission Act of 1920 as amended. 3, for the development of farm and home ownership on as widespread a basis as possible. 4, for the making of public improvements, and 5, for the provision of lands for public use. Since Hawaii had become a territory, some of the lands had always been either used or sold for homesteads or for home ownership. And while not a huge percentage in any way of the acreage, it was always one of the uses, and one of the provisions in our state constitution says the public lands referring to these shall be used for the development of farm and home ownership on as widespread a basis as possible in accordance with procedures and limitations prescribed by law. In the 1980s, the administration of Governor John Waihee, after consulting with neighbor island mayors, looked at a significant shortage of affordable housing, particularly on the neighbor islands, and made a decision along with the housing agencies that some of the ceded lands, including lands near Lahaina at Leali'i and lands in Kona at Laiapua, were going to be made available for development projects which included fee simple, affordable, and some low-income housing. The legislature was fully involved in this decision-making process. Since the time we became a state, a large number of statutes provided that ceded lands could be sold or transferred under certain conditions, but the legislature specifically approved of these projects, provided money for infrastructure, and in fact specifically provided that OHA was going to get 20% of the fair market value of the lands, and that for at least the lands at Leali'i, the Department of Hawaiian Homelands was going to get 30% of the fair market value in a cash payment. So the planning for these projects went on for quite some time. In 1993, the Congress passed the apology resolution, which among other things apologized to Native Hawaiians for the United States' role in the overthrow of the Kingdom of Hawaii 100 years before. In 1994, the Office of Hawaiian Affairs and some individual plaintiffs filed a lawsuit against the state. They alleged in the lawsuit that any sale of any of the ceded lands by the state was illegal, and that the state had no right to sell any of the ceded lands for the purposes of Leali'i or Laiapua, and had no right to sell any of the other ceded lands for any purpose. And among the things that the plaintiffs said in their lawsuit, and I quote, "The state does not have good marketable title to the ceded lands, and any sale or transfer would constitute an illegal conversion of lands because the Hawaiian people are the rightful owners of these lands. The state has neither legal title nor moral right to exchange, sell, or in any way govern these ceded lands." The lawsuit in various pleadings claimed that and this is the way the Supreme Court ultimately described the plaintiff's case, at the heart of plaintiff's claims before the trial court and on appeal is the apology resolution. The plaintiffs essentially believe that the title to the ceded lands is clouded as a result of the apology resolution. The state, starting in 1995, under the Cayetano administration, obtained an opinion from State Attorney General Marjorie Bronster that the lawsuit did not have legal merit, that the state had the full right to sell the ceded lands because the state was the owner. The state had received these lands in 1959, was the owner, and had the right that was given to the state in the Admission Act and by various statutes to sell or transfer the land which the opinion stated, as was clear from the Admission Act, that the ceded lands are held by the state for the benefit of all of the citizens of Hawaii, Native Hawaiian and non-Native Hawaiian alike. So the position of the state in the lawsuit from the beginning was that the state owns the ceded lands, that the legislature had clearly authorized these projects and the sale, that the Admission Act clearly authorized the sale and transfer of ceded lands for the purposes specified in the Admission Act, like providing homes or affordable housing, and that the apology resolution, while important, didn't change the legal landscape in any way. The case went on at the circuit court level for about 8 years, from 1994 to 2002. And in 2002, the circuit court, Judge McKenna, issued a decision in favor of the state. Hawaii Supreme Court for about 5 years until January of 2008. There is a dispute between the state and the plaintiffs about what the Supreme Court said and what the decision means, so all I can tell you is my perspective of what the Supreme Court said. The Supreme Court, in my view, said that following the argument that plaintiffs had made, that the apology resolution, which was at the heart of plaintiffs' claims, dictates the issuance of an injunction barring the state from selling or transferring any of the ceded lands, possibly for an unlimited period of time, possibly decades or generations. This is the major asset held by the state, and we believe two things. First of all, that the decision was wrong as a matter of law, and we also believe that if we left the decision unchallenged, we opened the state up to a variety of lawsuits by those who oppose any programs for Native Hawaiians, claiming that the state would be in violation of the trust set up by the Admission Act if we allowed this decision to stand. We felt that because of the oaths we had taken to uphold the Constitution and laws of the United States and the state of Hawaii, which specifically give the state the right to sell or exchange ceded land, and the laws this legislature had passed, which specifically sanctioned the projects at issue and the transfers of the land, that we had an absolute duty under our oaths to take the appeal that we did. The case will be heard by the United States Supreme Court on February 25th. OHA filed its brief in the case today. I'm still in the process of reading it and digesting it. OHA has retained excellent attorneys in Washington, as well as their excellent Hawaii attorneys. One of their lawyers is one of the more brilliant lawyers in America today, one of the more brilliant young lawyers in America today, and we know that that the Supreme Court will have to look at a wide variety of issues. One issue the Supreme Court, we're confident, will not be looking at are 14th Amendment or equal protection challenges to any programs that benefit Native Hawaiians. Although there aren't a lot of things that we in OHA agree on in the Supreme Court, OHA and the United States have all said that these issues are not before the Supreme Court, and we don't expect them to take it up. The final thing I'll say before Sherry goes and before questions is I'll just read very briefly from an editorial published in the Star Bulletin on October 12th, 2008, written by OHA trustee Walter Heen, former federal and state judge. And this is what Judge Heen said in the editorial, and I could give you the web address if you wanted it, regarding the petition for certiorari that we filed. Bennett had a duty to file the petition. The state court opinion could have tied up the state's ability to manage its lands for years, indeed for generations. That's how long it might take to resolve the self-determination issue. Bennett would have been derelict if he had not acted. And Judge Heen is correct. We had a duty to file this. We respect OHA's position in this. Ultimately, the United States Supreme Court will decide who's correct in this issue. But what we're defending in this case is not just the concept that the lands are for the benefit of all of the people of Hawaii, but we're defending our state constitutional provisions and the various laws passed by the legislature, which were put in issue by this lawsuit. Thank you.
Any weight to it. So our position has been that reconciliation does mean something. And, you know, we all know that for the Hawaiian people, land is very important and very precious. And it's part of their culture. It's part of what defines who they are. And so we asked for a moratorium on the sale of the ceded lands until the claims of the Native Hawaiian people were resolved. We looked to other jurisdictions to see what happened there, to make a determination about how to proceed in this case. And we saw that for the Santa Clara Pueblo Indians in the United States Supreme Court recognized and upheld a moratorium on the sale of their lands because of certain things that were happening. In Alaska, Secretary of the Interior Udall imposed a moratorium in the late 60s on the sale of the lands in Alaska until the claims of the Native Alaskans were resolved. In New Zealand, the courts imposed a moratorium on the sale of lands until the claims of the Maori were resolved. So having a moratorium on the sale of lands while there's a reconciliation process and a negotiation process going on with Native peoples is something that does happen and has happened other places and is very appropriate here in Hawaii. So here we have a situation where one branch of government, which is the Hawaii Supreme Court, one independent branch of government has issued a decision as to what their interpretation as the judiciary, as the court of law, what is the fiduciary duty of the state of Hawaii? And what information does the apology resolution provide? What information, what facts has the Hawaii State Legislature provided? There's several statutes that have been passed in the last 15 years by the Hawaii State Legislature that indicate that the legislature is interested in reconciliation with Hawaiian people, that the legislature is interested in moving ahead to have a resolution of the ceded lands issues. And so the Hawaii Supreme Court looked very closely at what the Hawaii State Legislature had done, and when it made its determinations on what is the fiduciary duty of the state of Hawaii to Native Hawaiian people, it also relied on its own jurisprudence, its own cases that it's decided, holding the state of Hawaii to the highest fiduciary standard for Native Hawaiian people. Another important thing that happened in the process of reconciliation is that when Kaho'olawe was returned to the state of Hawaii by the United States government and the U.S. military, the Hawaii State Legislature passed a law saying that Kaho'olawe would be held in trust until the formation of the Hawaiian nation. So we have many instances of a reconciliation process going ahead. We have many statutes being passed by the Hawaii State Legislature indicating an interest in reconciliation. We have strong statements by Governor Cayetano and Governor Lingle indicating that they too are interested in reconciliation and that they too are interested in seeing a resolution of the ceded lands issues. So we feel that our position is a strong one, and we feel that our position is the position of fairness and justice for Hawaiian people, and that's what we're looking for. You know, I've heard sort of hanging around parades of horribles, but I just wanted to read to you it says it's from Russell Pang, Chief of Media Relations for the Office of the Governor. This is Governor Lingle. And this statement was issued on December 4th, 2008 regarding 222 $32.8 million in general obligation bonds. Governor Lingle said, in connection with today's bond sale, the 3 top bond rating firms have reaffirmed Hawaii's bond ratings, which are at their highest level in state history. So this was just 6 weeks ago that Governor Lingle issued that statement. So the moratorium is livable. And in fact, since we filed the lawsuit in 1994, it's my understanding that for the most part, the state has not sold ceded lands. And so this is livable. And the Hawaii Supreme Court looked to testimony that was adduced at trial that the moratorium was something, even in fact, that when Governor Cayetano first came in, they did a self-imposed moratorium. So we think this is a very important case. We're extremely disappointed that the Attorney General and the Governor decided to appeal a decision of an independent branch of state government, the Hawaii Supreme Court, in a civil case. And we'll be there next month in Washington, D.C. So thank you.
Thank you, Sherry. And if you can stay, what I'd like to do is ask the Attorney General if he can join her. And I'm going to open it up for questions from the legislators.
For the Attorney General, I'm trying to figure out your argument. You're saying that the apology resolution does not have the force of law?
Our argument, both in the Circuit Court, in the Hawaii Supreme Court, and in the United States Supreme Court, is that not that the apology resolution isn't a law. It is a law. It's not the same as when this legislature passes resolutions which don't have the governor's signature on it and don't become public laws. It is a law, but it does not change in our view, the legal rights or obligations of the parties. That our argument is that in 1959, the Congress specifically gave Hawaii not just ownership of the ceded lands, but the right to sell or transfer them. That the state legislature has passed a variety of statutes, including relating to these 2 projects, which specifically allow for the sale or transfer of ceded lands, and that the apology resolution does not affect in any way the state's right under the Admission Act and various state laws to sell or transfer the ceded land. So that's our position. That's the.
Well, I have a number of subsidiary questions. I mean, the first is that if the apology resolution, in your opinion, does not materially change the legal landscape, I mean, it's merely a sorry, we did it and that's it.
No, but to use a word.
Why would Congress do that?
Well, to use a word that I didn't know the meaning of until I read the United States' brief in this case,
I have a number of
the United States, which has taken the side of Hawaii in this case in the Supreme Court, said not that this wasn't a law, but said that it was entirely hortatory, which meant that it was expressing a sentiment, but that it was not intending to change the legal rights or relationships. That doesn't mean it's not an important document, because an expression of apology is important in itself. But the United States' view was that it didn't change legal rights. At the debates in the Congress, for example, there were a number of senators who got up on the floor of the Senate and said, we're concerned that people are going to claim this apology resolution does change legal rights. And Senator Daniel Inouye got up on the floor of the Senate and said, I want to assure my colleagues that this is a simple resolution of apology. So our argument is that the meaning of the apology resolution is the meaning that Senator Inouye gave it. Doesn't mean it's not important, because Senator Inouye himself said it was very important, but that it is a simple resolution of apology and not one that changes legal rights.
If the legislature then changes, if we then take a policy that says that we do not want sale of ceded land, we impose a moratorium, that materially changes
Yes.
And how will that affect you?
Well, I guess what I would say is a couple of things, and I'm going to try to be cautious here because if the legislature should pass this statute, it's not my goal to have my remarks as Exhibit A in the lawsuit that will come.
Might be our goal.
Pardon me?
Might be our goal.
But the reason why I believe OHA has introduced the statute that it has is because it wants to provide an argument to the United States Supreme Court that the case is moot, and thus that they shouldn't reach the merits of the case. And that's why I believe OHA is asking the legislature to adopt it so quickly. It's our belief that it would not moot out the case and so wouldn't achieve its goal. But what it would do, and what I guarantee that would happen, is if the legislature passed this statute and it became law the next day, or maybe a week later, those who oppose Hawaiian programs and continually sue the state, and who we have fended off, at least under this administration, for 6 years on procedural grounds, they would sue. They would claim that the passage of this statute puts the state in breach of the Admission Act and would allow them to define the issues before the federal courts. The reason we have been able to fend off these suits in the past, and I think this is very important, because this was an argument that my department developed, was that people who are suing, claiming the trust itself is illegal, that is, it's illegal to provide benefits for Native Hawaiians, that they can't make that argument unless they join the United States as a defendant. And they have no standing to sue the United States, so their case is dismissed and the court can't consider the merits of their challenge. But the Ninth Circuit has said that if what you're saying is you're a beneficiary and you're claiming that the state is in breach of the Admission Act, then you do have standing, and the court would have to reach the merits of your claim. In this case, if the state, and if the OHA's bill comes up, I'll be required, as I always am, to lay this out in more detail in testimony. It's my view that if the legislature passed the statute that OHA has put on its website that I've read, that there will be a claim that passage of that statute for a variety of reasons puts the state in express breach of its obligations to all of its beneficiaries under the Admission Act. That claim by itself, it doesn't mean that the plaintiffs would win, but it would mean that they would have standing. And it would mean that the court would have to decide the merits of that claim. It would mean that they could frame the claim the way they wanted to. It would mean they could bring up issues regarding who the beneficiaries of the Admission Act are, and programs that benefit both the express beneficiaries, Native Hawaiians as defined in the Hawaiian Homes Commission Act, and Native Hawaiians that are otherwise defined by the state legislature. It would certainly be the irony of ironies were the legislature to pass the OHA bill, for that not to succeed in mooting out this lawsuit, which I don't believe that it would, and yet give those who challenge Native Hawaiian programs finally the basis that they've been looking for so many years to attack all of the programs that benefit Native Hawaiians. And if it comes to introduction of that bill in my testimony, I will lay out my concerns more detail with the bill, but I think that the legislature ought to proceed in this area with extraordinary caution, and I would certainly suggest the legislature should wait and see what the U.S. Supreme Court does. OHA's brief says to the United States Supreme Court, this is a state matter in its entirety. You have no jurisdiction. In fact, what's very interesting about OHA's brief is it doesn't even ask the Supreme Court to affirm the decision of the Hawaii Supreme Court. It doesn't even ask them to say the Hawaii Supreme Court was right. It asks them to either dismiss the case or to reverse the Hawaii Supreme Court's decision, which is, I think, very peculiar. But in any case, that's what the brief says. But their position is this U.S. Supreme Court has no jurisdiction. The Hawaii Supreme Court is right. And I think that the legislature ought to wait and see what the United States Supreme Court does, because if OHA is right, then there's certainly no possible reason to pass this statute in this form.
Okay, Mark, I want to take another tack on this, but before that, I want to ask Sherry to respond to the AG's contention that passage of the law opens up equal protection claims against Native Hawaiian programs.
Well, we were against the attorney. We didn't want the Attorney General to go to the United States Supreme Court even now. But I think there's a little bit of a turn in color on what the case is about and what the Hawaii Supreme Court decided. I mean, what the appeal is about, what we're arguing about at this point is what did the Hawaii Supreme Court decide, and what does that mean? And the Hawaii Supreme Court decided that the apology resolution and related state statutes do not bestow upon Native Hawaiians any ownership interest in the ceded lands. They said that that will be resolved in the political process. What is the ownership interest? What is the reconciliation process going to look like? And what will the resolution of that be? That will be in the political process. And we conceded that that's where the resolution would come. And so all we're looking at in the case is a moratorium. We're not looking at a transfer of any lands to anybody or anything like that. We're just looking at preserving the status quo during the interim period, and that's all we're looking at. And so I just think it's an injunction, and it's something that is livable in the state of Hawaii. And I read you the governor's statement about what a good job, the administration has been doing in the finances of the state. So I just don't think that, given the kind of interest that it is, which is injunctive relief and a moratorium, that I don't agree with the Attorney General's analysis.
If I could just add one thing, Senator. Well, I think that if Ms. Broder, who's a fine attorney and has other fine attorneys on her team, are saying that the OHA bill, which I assume they helped draft, is not going to give rise to any claim by any plaintiff that the state is in breach of its trust obligations under the Admission Act and is not going to lead to lawsuits which could harm interests, I assume they'd be willing to put that in writing to their clients and to the state legislature. I wish I was that sanguine about what it's going to do, because I don't think that this bill was drafted with a view toward those kinds of consequences. But if the lawyers who helped OHA draft the bill are certain that it's not going to lead to a lawsuit against the state claiming breach of trust with any chance at all of success. I mean, nobody can guarantee that somebody's not going to sue. Anybody can sue for anything, as we sadly see every day. But if their view is that such a lawsuit would be entirely meritless with no chance of success, they should be willing to tell the legislature that. I mean, the legislature will have to take that into account along with policy reasons and along with whatever our concerns are, but I'm sure that if that's their view, they'll be willing to tell you that.
Okay, Mark, and I wanted to take another tack. You talked about the apology resolution and saying that it's merely an apology. It doesn't have material impact. The Newlands resolution was very similar to this. In other words, the Newlands resolution, that was the resolution that annexed Hawaii. It was a simple resolution passed by both houses of Congress. and it expressed the sentiment of the United States at the time, which was to take Hawaii. Does it have the force of law?
Yes, and the
So
fact,
how does that reconcile with the apology?
well, because,
Passed the same type of resolution, passed in the same manner.
well, it's not the same type of
It
resolution.
was a simple resolution that passed in both houses.
Well, Senator,
As a president's signature on both of them.
just let me know when you're done.
Okay.
That a resolution, as everybody in the Hawaii Supreme Court case agrees, is the same as a law. There's no difference between a resolution signed by the president and any other type of law, but the effect of any law depends on what's in it. If the Congress had wanted to affect Hawaii's ability to sell public trust lands in the apology resolution, it presumably would have said that. Now, we don't think the Congress could have done that. We don't think that the Congress has the constitutional ability to take from Hawaii the right to sell the lands that Congress expressly gave to us in 1959, and they certainly don't have the right to take it from us without paying us for it. But they didn't say anything like that. In contrast, the Newlands resolution specifically said that it was accepting the cession of lands from the Republic of Hawaii. It was taking fee simple absolute title and ownership of the lands, and it was taking all of the property that was in the hands of the Republic of Hawaii and making Hawaii part of the United States.
I mean, is the Newlands resolution and the apology resolution the same type of act? And they are. They're both law. They're both passed by both houses of Congress and signed by the President of the United States. So they're both law. You know, so I mean, it's interesting. Sometimes people call it the Newlands Law and the apology resolution to sort of try and make it seem like they're different. But the apology resolution is a public law, same way. So.
Well, I mean, you know that the Newlands resolution actually was the departure from practice in Congress. I mean, it was the first time that this vehicle was used. And in fact, there's a huge body of literature in the United States about the beginning of empire for the United States based on the Newlands resolution. Empire Can Wait, America's Opposition to Hawaiian Annexation, was a thesis done in Michigan, really examined the U.S. opposition to this methodology of circumventing the constitutional requirement for a treaty of annexation, and instead using the resolution process. I mean, it has a lot of impact for us today, because if we're trying to say that the apology resolution doesn't have the force or doesn't have an operative part, then we have to really go back to the Newlands resolution too, and everything that flows from that. So I'm trying to, I mean, I'm not going to ask you to answer that. I'm just saying that this is where my thinking is on it right now. And I'm going to yield the floor to others for questions.
Okay, members, any questions? Representative, well, Senator Rick Galatario.
This whole argument seems so sterile. It's like a textbook. There's no humanity in this thing. That's what, for this senator, bothers me the most. Mark, what you're saying is that you're doing this for our own good.
What I'm saying, Senator, is that I've taken an oath to uphold the Constitution and laws of the United States and the state of Hawaii. I don't, nor would I be allowed to, pick and choose which laws I uphold and which I don't by my own personal view of whether they're good laws or not good laws. And you wouldn't want me to do that. I don't think anybody would want any attorney general to decide, I'm going to take these 100 laws and I'm going to enforce them, but these 100 I'm not going to, because I don't think they're good laws and I don't think the legislature should have passed them, or in my view, they're immoral. I mean, in a way, as I understand it, there's a debate going on outside in the courtyard kind of on that issue about the morality or immorality of certain laws that the legislature has on a completely different subject. But presumably, you don't want your Attorney General deciding, I'm going to enforce this law or not this law because I agree or disagree with that position. That the way people have to change laws is to elect representatives who agree with their view of public policy. But the fact is, Senator, it's this legislature which specifically sanctioned these projects which this lawsuit challenges. And it is the statutes of the state of Hawaii that have been on the books for more than 40 years, which specifically allow for the transfers of ceded lands, and the Admission Act, which is the very foundation of the state, that specifically allow for the transfers of ceded lands.
So Mark, what you're sharing with us is that the state does have the authority to sell ceded lands right now. That's not the law.
Well,
What is the law?
it is my belief, the laws on the books give the state the authority to do it. In my view, the Hawaii Supreme Court said federal law stripped the state of that authority. And what we're asking the United States Supreme Court to do is to say, no, the apology resolution did not in any way affect the state's authority to transfer ceded land.
You still never answer his question.
Does the governor intend to sell
To sell what?
ceded lands?
The governor has said that she has no present intent, but of course we have a Supreme Court injunction against it. So if we tried to sell ceded land at this point, we'd all be thrown into jail for contempt of court. In addition, the testimony at the trial in this case was that because of this lawsuit, nobody could get title insurance on any ceded land that we would try to sell. So if we succeed in winning this lawsuit, the state will have the authority to sell, transfer, and exchange ceded land, and then the decision makers in the state will have to decide whether that's wise or unwise. But it's our view that the state clearly ought to have that authority in order to manage its assets. How it exercises that authority is up to its decision
So in your
makers.
opinion, the state doesn't have the authority right now?
It's not my opinion. The Supreme Court has ordered the issuance of an injunction saying you cannot sell or transfer, and it's that injunction which we're trying to get overturned.
Sherry, do you have a response to any of that?
Well, there is an injunction, and so at the present time, they can't sell. Oh, I'm sorry. Yeah. There is an injunction, so at the present time, they can't sell. But, you know, the purpose of the litigation and the way the Hawaii Supreme Court viewed the issue was that this was a time for reconciliation with Native Hawaiian people for the wrongs of the past. And that to take the next step was to put a moratorium and preserve the status quo while the reconciliation process was going on. And so once the reconciliation process is over, then the state would have the authority to sell the land. So underlying is the state's authority. It's just that right now there's an injunction on the sales. The Admissions Act itself says that in giving the lands to the state of Hawaii, that they will be administered according to the laws and constitution of the state of Hawaii. So that's our point on appeal. One of our points on appeal is that this is the Hawaii Supreme Court interpreting the laws and constitution of the state of Hawaii, and in particular, what is the state of Hawaii's fiduciary duty to Native Hawaiian people?
And Mark, why is the administration so compelled to take this to the federal level when the state Supreme Court said what it said?
Because it's our belief that the state Supreme Court, relying incorrectly on federal law, stripped the state of sovereign rights that the state has and that we had been provided, and that we believed that it was our obligation to defend the laws that this, among other things, the laws that this legislature had passed and the Admission Act itself, which provides this right. So we believed that it was our duty and our obligation to do it, and we did what we thought was what was our obligation to do.
You know, your PR is terrible in this. Absolutely terrible. Nobody understands what you're doing. Nobody understands what you're trying to accomplish.
Well, I'd
We
respect.
got Hawaiians over here who are up in arms, and I find it ironic that they're chanting outside. Which has nothing to do with this.
Well, Senator, two things. First, I mean, I have to respectfully disagree with you. There have been a lot of people who have said that they do understand exactly what we're doing, but we're not doing it because we thought it would improve our PR standing. I mean, we didn't take this appeal because we thought it would make us more popular, and we didn't factor in the fact whether or it would or it wouldn't. We did it because we believed that what we were doing was the right thing to do given the Constitution and laws of the state of Hawaii. We understand that there are those who disagree with us, but again, whether we were going to get bad PR out of it or not would not have been a reason for us not to do it.
No, that wasn't the point. My point is that if this is something that's good for the Hawaii, then what are we doing here today? Because nobody can figure this one out, not nobody. Certainly there's some of us here who can't really figure out the compelling nature to take it to the higher level when the state Supreme Court has already spoken. Two governors not moved on this hill. The one Hawaiian governor did accept the home rule state, but now the current governor is taking this to the federal level. It's kind of ironic, but I just needed to try and understand what is compelling the administration to do housekeeping now with this bill. I yield the floor. I just wanted to share some of that.
Thank you, Senator. Representative Sylvia Lu.
I yield the floor. I just wanted to share some of that.
Thank you, Senator. Representative Sylvia Lu.
Attorney General, I wanted to just clarify your position that the OHA's moratorium bill will lead to standing other claims. I just wanted to clarify that you mean standing under the federal claims as opposed to state claims, right?
Yes.
14th Amendment claims.
Well, I'm not saying that it's going to lead to a successful 14th Amendment lawsuit. What I am saying is that I believe that if this bill passes, there will be those who will sue the state claiming that they are suing to enforce the terms of the trust, the Admission Act, and under a variety of Ninth Circuit decisions, the Ninth Circuit has said that anyone who is a beneficiary of the trust, which is all the citizens of Hawaii, have a right to sue to enforce the trust. That there will be lawsuits that claim that the OHA bill, and I haven't seen any other bills, so I'm just talking about the specific OHA bill, there will be those who claim that if the state enacts that into law, it will be in violation of the trust, and that therefore they have standing to raise those claims, and will also, I am sure, raise additional claims as well, and will tee up the claims in the way they think best suits them. So I do have very real concerns about that.
So I think that's part of the issue because, many of us haven't seen the OHA bill, and I'm not sure exactly what's in the OHA bill, but you seem to preface it as, if we were to pass what's in the OHA bill as a language associated in the OHA bill, then it will lead to potential claims. But after all, the sale of ceded lands is a political question, and it's up to the policymaker. And if the policymakers want to make a statement that we do not condone the sale of ceded lands, if we were to pass a sitting bill just stating that policy of a prohibition and a ban of ceded lands, I don't know how that in itself will lead to a federal claim. Because after all, we do that in submerged lands, we do that in other type of sale issue, so I don't see how that in itself, a simple policy statement by legislators prohibiting future sale of ceded lands is going to lead to any type of future potential 14th Amendment claims. And so I think that's why there's some confusion.
What I'm saying, Representative Luke, is that I believe that it will lead to claims that if the state adopts that as a law, and the OHA bill was on its website, so I read it, that would lead to claims that the state, by passing that law, is in violation of the Admission Act. And if that bill comes up, we'll provide testimony about it. I'm not saying the state can't regulate the sales of ceded land. That bill has a number of different provisions in it, and so I'll wait to comment further on it if that bill comes up for a hearing. But I would just ask you, take a look at their bill and see what it says.
Right, but it's not, we don't have to just pass whatever is brought to us. So what I'm basically asking you is if the legislature makes a statement, a bill stating simply that we want a moratorium on the sale of ceded land, and simply that, not any type of breach issue, not any type of other issues that are related in the OHA bill, but a simple statement, clear statement by the legislature on the ban and prohibition of sale of future ceded lands, then what would the position of the Attorney General be? Do you think that will still provide or still lead to potential 14th Amendment claims?
Well, the way you've stated it, I believe it would absolutely lead to a lawsuit that bill put us in breach of the Admission Act. I don't think that bill would directly lead to a 14th Amendment claim, but I think it would put us in significant jeopardy for a claim that we were in violation of our trust obligations under the Admission Act, would give the plaintiff standing, and would have some real significant risks in a federal lawsuit where plaintiffs have standing. I'll just say that there's not everybody out there who agrees with the Ninth Circuit's decision on our argument as to who has standing and who doesn't to raise 14th Amendment claims. And in a case like that, that decision would almost certainly be subject to conceivable review, something that we don't want to happen. Because in a case where somebody has standing to say you're violating the Admission Act because you're doing something contrary to your trust obligations, even if that particular claim doesn't involve the 14th Amendment, it opens up a lot of cans of worms. And if I have to come testify on specific bills, obviously I'll do what I normally do here and point out potential problems. But the bill that you've described, I see as significant problems with regard to people claiming a bill like that would put us in violation of the Admission Act and our trust obligations.
Because, Broder, would you agree that a simple bill is just a policy statement by a legislator and it wouldn't necessarily lead to potential claims in federal court? I just don't get the connection.
I think you ask a very good question, and the way you phrased it seems to me to be a useful hypothetical way of looking at it. And I guess as I look at the Admission Act, it says that the 5F shall be interpreted as the constitutions and laws of the state of Hawaii provide. So I don't see why, if it was a simple moratorium with no, that was the policy of the Hawaii State Legislature, to have a moratorium on the sale of ceded lands. I don't see why that would put the state in jeopardy. Of course we all know this is a, free country and people can go to court and file lawsuits. So that doesn't mean lawsuits wouldn't be filed, but I don't see why, if it was a simple statement as you describe, why that would necessarily be, raise a bona fide issue with regard to the Admission Act.
Senator Michelle Kidadi, followed by Representative Chris Lee, followed by Representative Balani, followed by Representative Balani.
Hello, Mr. Bennett.
Aloha.
You stated earlier that you took an oath to uphold the law of the state of Hawaii. So if this body were to pass a legislation that would prohibit the sale of ceded lands, moratorium on it, would you uphold that and cease and desist your current lawsuit with the Supreme Court?
Well, I don't think a law that said there's a moratorium on the sale of ceded lands is something that says cease and desist your lawsuit.
But clearly, such a law would mean no sale of ceded lands.
Okay, I guess, again, what I'd say is that passing a law about the sale of ceded lands, in my view, isn't a command to the state to abandon its Supreme Court appeal.
Answer the question, yes or no. That's all we want to know.
And I'm baffled, but I'm done.
Representative Chris Lee.
Only program, just yes or no.
The last two questions actually touched on where I kind of wanted to go with. Just as an aside, I wanted to ask, are there any conditions that you can identify that would cause the state to withdraw its appeal?
Not now that I've seen OHA's brief, no.
Representative Balani.
Thank you, Chair. This question is for Attorney General. Thank you for being here.
You're welcome.
I want to go back to kind of the line of questioning that Representative Luke had, and I'm trying to understand why this moratorium is set up for these other lawsuits. And basically, is the presumption that the moratorium is only good for Native Hawaiians, and that would then, in effect, cause other beneficiaries to have standing to challenge the moratorium? Is that the basic premise and assumption?
I think there are a couple of different possible challenges to the statute that Representative Luke laid out, and honestly, I don't think it's in the state's interest for me to detail them all here to provide people kind of with a roadmap as to how to sue the state if that statute were passed. But if a statute's introduced, we'll obviously have to testify as to potential problems that we think are real. But I've looked at the OHA statute. I've identified in my own mind what I think are some potential problems with it. But I don't really think my listing them here is really in anybody's best interest.
Well, maybe for the public record, I think for that interest, I think it's important to state that whatever OHA brings to us as a legislature, we will mull over, we will look at, and maybe this notion that the moratorium is somehow only good for one beneficiary class is mistaken. The moratorium may very well be good for all the people of Hawaii until the reconciliation process has occurred, so that there will be no clouded title over any lands that may be in the future sold. I mean, and that's, I think, something that we will have as a discussion as a legislature. But this notion that somehow setting ourselves up for future federal lawsuits, I don't think that should, I don't think that fear tactic should prevent us from looking at and exploring this as a policy option for the state.
Well, I don't think it should prevent the legislature from exploring things as a policy option. But if, for example, the main motivating factor behind the OHA bill and the immediacy need for it to pass is to try to moot out the current lawsuit, that raises its own questions, and whether the state or the legislature wants to take a different approach to ceded land sales and transfers is a different issue from the issue of passing something really, really quickly with the intent of trying to moot out the current lawsuit. Those are two different questions.
Very good. Any other questions, members? Representative Kono-Chong.
Thank you, Chair. Ms. Broder, I wanted to follow up on this issue of what the Attorney General said, because on the follow-up of Senator English, it was unclear what your answer was to him. So are you saying that the Attorney General's legal opinion that people would have standing if we did pass the OHA bill is just not, it's out there, it's not a legal opinion, or?
I'm not saying that, I don't think I'm prepared to comment right this minute on whether or not people would have standing or not.
Okay,
But I think that, Senator, Representative Luke asks a very good question, and that I would like to take additional look at.
Because clearly as policymakers, we want to continue the programs for Native Hawaiians and ensure that that does not get punished and that nobody can take that away. So clearly, I guess you need to take a look at it. For now, we'll leave it at that. For Attorney General Bennett, how, and I'm not an attorney, so I just need to clarify. The question, it seems, at the court is not so much, it's not whether we should sell ceded land. It's the question of whether or not the state has the right to.
Yes.
And so that's kind of the question that you are asking the U.S. Supreme Court. Not should we, but does the state have the right to sell it?
Yes.
Okay. My other question is with issuance of GO bonds. Clearly, one of the issues that was brought up in, I think, in a finance hearing is the issue of the economy and trying to issue GO bonds. Clearly, the administration had a hard time in December. Where are we at? Does this issue affect that?
I think that if we win the Supreme Court appeal, this doesn't affect our bonds. We have been listing this case as part of our bond disclosure now since it was filed, or shortly after it was filed. We've obviously changed the disclosure since we lost in the Hawaii Supreme Court in January. On the bonds. I think that there's some uncertainty out there, but I believe that probably the general feeling is it's not really, since the Supreme Court granted certiorari, it's not really an issue right now. If the Hawaii Supreme Court decision as written stood, I think it would be an issue, but as I said, the OHA brief is interesting in that its conclusion doesn't ask the Supreme Court to affirm the decision of the Hawaii Supreme Court. The only two options that the brief takes the position of asking the court to do are to either dismiss the case for a lack of, well, I don't want to say it exactly wrong, but it's either to says the petition for a writ of certiorari should be dismissed, which is an argument to the court they don't have jurisdiction. I think given that they've granted certiorari, that's an unlikely argument to succeed. It then goes on and says, in the alternative, the judgment of the Hawaii Supreme Court should be vacated and the case remanded for further proceedings. So there is nothing in the brief which asks that the Hawaii Supreme Court decision be held to be correct or affirmed. So since I don't believe the U.S. Supreme Court is likely to dismiss the case as improvidently granted, which is what's being asked for, then both sides are saying the decision ought to be reversed if the case isn't dismissed. So I think that given that procedural posture, it's not going to have an effect on our bonds unless the case is dismissed.
Okay. Ms. Broder, so I'm assuming he had it correct. That's all, the two options he asked for.
Well, I think the interpretation of the options would be a little bit different. I mean, basically, we argue that the Hawaii Supreme Court based its decision based on state law. And so therefore, there's no federal question. So therefore, there wouldn't be any reason for the United States Supreme Court to reverse the decision of the Hawaii Supreme Court. So in effect, by dismissing the appeal as because it doesn't raise a federal question, that in essence is an affirmance of the Hawaii Supreme Court. But then, in the alternative, what we say vacate and remand to the Hawaii Supreme Court for further proceedings in order to give the Hawaii Supreme Court an opportunity to clarify its opinion that it is based solely on state law. So my interpretation of what we're asking for, I think, is a little different than the Attorney General.
And if I may, one more question. And sorry, I'm not doing if it's based on state law, the one thing I did hear, and I keep hearing from both of you, is the U.S. apology resolution. So, and that seems to be the crux of the issue for both of you. So, I guess what you're saying is the ruling is on state law, but using that? How does that work? Sorry.
We say that the apology resolution, which is very similar to the concurrent resolution passed in 1993 by the Hawaii State Legislature, it provides factual findings that provide information to the state of Hawaii in assessing its fiduciary duty. And that's the way that the apology resolution is being used. But the Hawaii Supreme Court was very clear that it wasn't just the apology resolution, it was the apology resolution and related state statutes.
Members, any more questions? Yeah, I have a question. And this is for Mark. Do you believe that if the legislature was to pass a moratorium bill, are you confident that you will win this case? Would it matter, in your opinion?
It's my belief, and of course I'm biased, it's my belief that even if the legislature passed the OHA bill, I don't believe that the United States Supreme Court would choose not to hear the merits of the case because it's moot. I am certain that if you pass the OHA bill, two things would happen. Or I should say, I feel it is very likely two things would happen. One, OHA would make a motion in the United States Supreme Court, or whatever the technical way you bring these things to the United States Supreme Court, that the case is moot, and ask the court to dismiss it on those grounds, and that somebody would file a lawsuit claiming the state was in breach of the Admission Act. Again, I'm only talking right now because it's the only bill I've seen, the OHA bill, but I believe that both of those things would happen. I can't predict what the success of the lawsuit would be. I don't believe the United States Supreme Court would dismiss the case as moot, even if you passed the exact bill that OHA has propounded, but I'm certain they would, or I'm virtually certain, they would make that motion.
And Sherry can answer the question as to, with the OHA's legislation, in your opinion, would that help with getting this particular case dismissed? In your opinion?
Well, I think the legislation would be an affirmation of the finding of the opinion of the Hawaii Supreme Court, and would be another avenue for having a moratorium. I don't think I can speculate on whether or not it would result in having the decision or the appeal dismissed.
Members, last opportunity for more questions. Anybody? for more questions. Anybody? Representative Carr.
Thank you, Madam Chair. Sherry, you did indicate that based on the comments of Representative Luke and some of the other discussion, I think it's pretty clear with respect to this body, we are very concerned with opening up any potential lawsuits that would endanger Native Hawaiian programs. I don't think there's any question about that. I think you did indicate that you would revisit the OHA's bill and look at the language to see if there is any way you could tighten up the language to ensure that we're not opening up in the event we do move forward with the proposed legislation. So given the fact that time is of the essence, if you could get back to us, that would be great as soon as possible. That would be fantastic.
Thank you.
Thank you so much.
Any more questions, members? No? We'd like to thank you very much for coming today. Members, we just have a few more items on the agenda.
I wanted to make clear that the four Hawaiians on the Senate will be sponsoring a moratorium bill on the sale of ceded lands, regardless of what the Attorney General may.
Ae o ka poe o Hawai, o mau ka olelo o Hawai. Hawai po'oi, Hawai po'oi, Hawai ai, ke ai. Halloween,